So that brings me to legal risk management, which is, I talk about a couple of things that you should look at in any situation as a general paradigm. Number one, what's the magnitude of the risk? What could possibly happen? If the FTC gets its hands in your advertising, count on a multi-million-dollar judgment. Good chance that could happen. The magnitude can be enormous. So, are you a company? Are you Uber? Do you have are you Google? Do you have a huge litigation team? Or are you a small practitioner in a small town? Are you an institution with a great reputation to defend? So what's the magnitude of the risk? What's the likelihood? This is one we talk about a lot. I wrote a blog post some years ago. I don't even know where this post is, but somebody found it. And they called my office and with some really complicated scheme. Not supplements, but since I deal with the whole gamut, all of these bleed into each other. They're very similar situations that come up. And they said, Attorney Cohen, again, you said in your blog post, which I don't remember what I put in a blog post 8 years ago, that enforcement tends to be light, so I'm assuming everything's going to be okay. Well, I assume that if I just buy a lottery ticket, one of these days I'll win, because a good friend of mine who's a psychic told me that I would. And so, you can assume whatever reality you want, and now that I've said it on video, I hope it comes true, but, I don't know if it will or won't come true. So, yes, I said in a blog post that enforcement is light, but enforcement priorities change. And going back to Todd's slides, I would actually take those two words and I would make them like 50-point font. Does anyone know what the two words are? Todd knows. Enforcement discretion. It's huge. There's a lot of enforcement discretion. The rules aren't always yes and no. There is a lot of thou shalt not, but there isn't a lot of thou shalt. The law doesn't say, here's how you construct a viable business. These are simply things that you do and you're compliant. HIPAA does that, but it's so complex and convoluted that there's actually a bill introduced into Congress to translate HIPAA into English. So, if you guys are doing some lobbying to revise DSHEA, bless your heart, good luck. There's a lot of epistemological chaos, and, may it happily be resolved. And in the meanwhile, we're in the human condition, human state, and there's likelihood, very hard to assess. But we do give a read. We do give a read. Some things are riskier than others. And people like Todd and myself can say, here's where you're more in the red zone. Here's where I usually like to say, you're heading toward a yellow light. How many seconds do you have to get there? How fast are you going? How likely are you going to make it through the yellow before it turns red? And oh, by the way, there's a camera. So what do? Sometimes we accelerate. Sometimes we slam on the brakes. That's the decision point. What's the benefit? Are you getting a 1% margin on these supplements in your practice, but you're and what's your risk tolerance? But you're very nervous, you're having recurring dreams about some malpractice lawsuit, whether you're in New York or Connecticut or Hawaii. What's your risk tolerance? Or are you a startup? Do you want to roll the dice? Do you want to take a chance? How aggressive are your claims? And what are your alternatives? What are your alternatives? Is this the one word that makes $1 million difference? Or is it, hey, I'll just say supports a healthy blah, 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 and I won't say versus such and such disease? What are the alternatives? So that's really where the nuanced legal advice comes in. It's really here more than the yes-no decision. That's where we come in. So number one, know the possible lines of legal attack. I talk about a couple of different issues today. Two, understand that there are a number of sources of legal exposure. It's not just the FDA. It's not just medical malpractice. It's a whole number of things, and you got to spot the issues. Understand risk and the spectrum of risk, and understand risk mitigation. If you're a practitioner, have disclosure statement. Have your claims legally reviewed. So know the enforcement hot buttons. So these are, where did I get this? I think I got this off something on the FDA website where they talk about the different ways you can make an implied disease claim. Like, for example, using OTC claims such as antiviral or antibiotic. I've seen a lot of companies come with claims. They say anti-this, anti-that. Those are OTC drug claims. But it's supported. You know, all the babushkas in such and such a village use it, and it's antiseptic. Well, that's not competent and reliable scientific evidence. And that's a disease claim. So have the claims reviewed and get a legal read on each and every claim. You might have more claims than you think about your product. There might be more. If you actually go page by page and through all your marketing collateral, you might actually see a lot of claims. So that's basically what I want to say, and I do have the slides here, and Eric, you can take them from here. I finally put them up. And also I have a book, Your Healthcare Company's Excellent Legal Adventure. I thought that was a good title. And it is. It's a very fine, excellent legal adventure. And there's a chapter here on FDA and FTC issues. That's basically it. So I say don't roll the dice, get legal advice.